Thank you everyone for joining. I think we've got a few more minutes, so it's lovely to have you with us this evening. So just while we're waiting, got a bit of a screen share there, but I might put myself on mute until we sort of hit 6 o'clock, ready to go there. So still got about 3 minutes or so. Well, thank you everyone for attending. I hope you are all well. Welcome to our third webinar this year. And again, we're covering off a third set of changes that have been introduced. So I'd like to welcome everyone to those owners, committee members as part of the Jamesons Group. My name is Paul Culby and I'm the group licensee in charge here at Jamesons, and part of my role is also working with our owners and committees and keeping them up to date with legislative reforms and changes that are being introduced. As part of today's session, I'd just like to commence by acknowledging the traditional owners of the land which I am presenting here from today, being the Gadigal people of the Eora Nation, and pay my respects to elders past and present. Now we've struck 6:01, so I'd like to be able to get into today's session. And today's session is very much covering over some changes that we will see, which will commence on the 27th of October, 2025. There's a list here of some of the changes that you will either hear about or also see through the media provisions. And these are key changes with two additional items that we're going to cover also by services that we will provide to our schemes. And these commence with enhanced fair trading enforcement. This is covering off for repairs and maintenance. financial hardship assistance requirements, standardized payment plans for overdue levies, building and facility manager duties and disclosure obligations. So we reference building managers for strata schemes and facility managers for community associations and deposited plans. The tribunal having the powers to change and or for strata and building management agreements that have these unfair terms that are being applied. And we will then finalise off today's session outlining the new reports that you're required to receive applied by Section 55 of our legislation, called the Delegated Functions Report. Commonly strata managers call it their strata managers report, but these are related to as delegated functions reports. And finishing off the session today is our new reporting provided to our owners. This is our detailed financial management fee report that we'll show you that will become accessible from pretty much from the 1st of November. So in commencing today's session, we're going to start with the changes that are being applied and get everyone across what to expect. Now, the key changes that you'll hear and see will cover off things as the enforcement for repairs and maintenance by fair trading. The changes will apply also to community associations and depositor plans as part of their implementation applicable to strata plans. Financial hardship and assistance requirements, standardised payment plans for overdue levies and structures in the way they're handled, and touching on those two final points of duties of disclosure and obligations by building and facility managers, and again, the tribunal being able to enforce powers on unfair contract terms for building management and for strata manager agents agreements. So starting off today's session, we are commencing with enhanced fair trading enforcement on repairs and maintenance. To commence today's session, what we're seeing that is being applied as a change is commencing on the 27th of October. Fair trading, New South Wales Fair Trading has new powers that apply to compliance and enforcements under the Strata Schemes Management Act for strata schemes and the Community Land Management Act. This is associated to repairs and maintenance of schemes for any complaints they may receive or investigate. They will have powers to issue enforceable undertakings and compliance notices and possible penalties for breaches of statutory maintenance duties. And when we talk about maintenance duties, we're talking about the standardised repairs and maintenance or capital works that may arise as a duty and obligation to repair and maintain common property. When we look at the enhanced fair trading enforcement on their repairs and maintenance and the framework that they will apply, there are aspects here that they will have to approach any complaints or inquiries that result from owners or committee members as such. They have investigative authority and now can investigate potential breaches concerning repairs and maintenance. They will be able to seek documentation and information requests from strata managers and managing agents, and they have powers to require relevant documentation and information to support their investigation and make those requests that these documents be provided. Thirdly, they also have the premise inspection rights. So New South Wales Fair Trading officials have been given powers to enter the premises, working with residents, owners and strata managers to carry out inspections related to any compliance checks that they resolve issue early. Now, on these three items here, these are raised by points of not just standardised common issues of plumbing, etc., but they are a vast range. They can relate to fire safety means, waterproofing, leaks, etc., a whole bundle of range of maintenance aspects. What we know from the new applicable legislation is that for consequence of non-compliance, Enforceable undertakings, so formal commitments or orders to carry out the repairs, can be issued upon the owners, corporations and schemes. They can issue official direction notices which require specific actions to be undertaken. Financial penalties for breaching these obligations. And there's a worst case for non-compliance, like what I like to call the do nothing, legal proceedings, they in case of serious or repeated non-compliance. So this is quite an enhanced means of taking it seriously. However, Fair Trading and New South Wales government say that the highest number of complaints they receive are associated to repairs and maintenance. They believe by applying this, it should be able to undertake and reduce those complaints and address those matters in that regard. What we know and some consideration that we make as strata managers for our schemes and clients is to review any maintenance backlogs. There are links that will be shared after this provided by New South Wales government on doing a building health check, undertaking a review of your building's capital works fund, its maintenance issues and budgets for urgent repairs. And primarily, if you're aware in terms of immediate actions, addressing any safety issues quickly. In an ongoing basis, it is being reformed and it is being enforced that the record keeping of maintenance decisions, responding promptly to repair requests, scheduling regular inspections, and ensuring your capital works funds are adequately maintained is an ongoing priority for all our schemes. As strata managers, we always recommend to review your 10-year plan. And what we'll actually see later on this year, actually not later on this year, about April 2026, a standardised form being released for a 10-year capital works fund plan. So this should be able to assist schemes in preparing a standardised format. What that looks like, there's probably a bit more in the making, but we will definitely be able to update you as soon as this information is released and shared in due course. Now, what this means for you is, in view of these enforcement powers, it really takes an approach that it means faster resolutions of repairs and maintenance issues, more assurance to the owners, to the consumer, that the building will not fall into disrepair due to inaction, a reduced risk of fines or compliance orders being imposed on their scheme. These provisions of orders that are being issued that they mention are also available within a register as well. New South Wales government's approach and Fair Trading's approach is by increasing transparency and enhancing provisions of safety, along with long-term protection, also protects your property value. So looking at that as strata managers, as schemes, as committee members, you may be looking at this going, wow, this is a lot to take in. But our strata managers have also been trained on these sessions and will be undertaking those reviews. And if you have any concerns, please reach out to them. They're ready to go and ready to fire away right now, a week before the new legislation being applied. We go on to the financial hardship assistant requirements. Now, there's no doubt there's been a lot of discussion across our country about the cost of living and the aspects of how certain scenarios are being applied in terms of financial hardship and payment plans. I've got a question here, and I might answer that before I actually proceed on that, is how does Fair Trading become aware of problems that require them to make a visit to the premise? It's actually a very good question. Complaints can be arisen from owners, tenants, committee members, which would then result in them being able to undertake an inspection or seek the strata manager to provide records. I'd imagine they first be provided with the records and then be able to then determine if they are to investigate that. By the way, please feel free to put any questions and answers in the Q&A tab down the bottom. We're here to answer as much as we can. If we get to them all we definitely will. If we don't, we will definitely be sending Q&A and FAQs straight after today's session, along with this recording and the presentation there for you. Now, back to my financial hardship assistant requirements there. What you'll be seeing is a lot of statements, and this is directly from New South Wales Fair Trading's website. Your levy notices are going to see a little bit more content, especially if you're receiving them via email, links to a new mandatory financial hardship information statement. As you can see on the right there, that is the standard format that's being included. And the statement actually provides important information for owners experiencing financial hardship. Now, straight after this, I'm going to go through payment plans on how they're best managed and handled and how we will assist you. But this statement is critical to understand that it is not an optional requirement. It's actually a mandatory statement that has to be provided with levy notices. And there is also accessibility to putting provisions of the National Debt Helpline.org.au link there, and also the understanding of levies. They're also put it in multilingual accessibility and the access to contact New South Wales Fair Trading. Now, this statement in summary provides owners with information about payment plan options, financial counselling and their rights. And thirdly, the wording must be used by New South Wales Fair Trading text. There's no modifications allowed. We did have a few queries and questions saying we'd like to have this wording changed. Unfortunately, this is a statement that must be included in its current format. Translation links will also be provided to support non-English speakers and anyone that requires translation. It's really accessible and user-friendly that way for all our owners. In terms of financial hardship assistant requirements, we've definitely reviewed that. And on the right, you can see a little bit of a sample of what we call our fly sheet, but that is the email body of what will owners receive. And we've developed some information there on pages to assist our owners and support them. Also our committees in handling this. But we've updated the email body for all levy notices and added a page to those on post levies with this information. The provisions of templates that we use will be there dedicated on your behalf to ensure your scheme is compliant when the levy notices are issued, and our teams are all trained in this area. We've additionally, thank you to the help of our wonderful marketing team and website designers, created a website with information on financial hardship and payment plans, a little bit more user-friendly with direct links to assist owners in understanding that. Our teams are encouraging open dialogue and proactive contact from owners experiencing this hardship. We're there to support you, we're there to service and give you the required attention that is needed. So if you know of owners or in the position of experiencing financial hardship, you'll have a clear, consistent information about your rights and support options. Secondly, you'll have access to free financial counselling mediation services to resolve any levy disputes. And the one thing is greater fairness and compassion in the way schemes handle overdue levies. So in summary, the provisions of financial hardship, and we're going to go into payment plans, which will summarise this, it just does not permit a scheme to authorise action such as debt collection without reminders or the offering of a payment plan. This is the first time we've seen this in our industry, and this is taken quite seriously and mandated. So it'll be something to look out for when you get your new levy notice next time. There's a standardisation of payment plans for overdue levies, which has also been introduced. And today we'll be running through what that looks like. Commonly, payment plans are submitted via email, via telephone, letter, and we are seeing standardised payment plans for overdue levies. The important part today is to recognise that when you receive these standardised payment plan options, it is actually being embedded into a committee to having to consider them, and also the rights of an owner's corporation as well when considering that, and the rights for an owner that's submitting the payment plan. So what's changing? We'll see from the 27th of October, owners must use the new form. So we have a request for payment plan for overdue contributions. A little bit of a sample text is there, and we'll provide you accessibility to the payment plan links. The form itself is for owners, corporation, associations, or deposit plans. These requests must consider each request separately. Blanket refusal by any scheme is not permitted. They must be considered on a case-by-case basis. It is also required that a response to any payment plan is provided to the applicant within 28 days, and it must provide clear written reasons if refusing a plan. So a lot of the time, we're hearing payment plans can be carte blanche banned. Irrespective, they must be considered on a case-by-case basis, and schemes do have the right to refuse a payment plan. Now, these refusals, as detailed in this screen here and this slide, must and can only be reasonable if approving the payment plan would leave your scheme without enough funds to meet its obligations. And this may include situations whereby the administrative or capital works fund would fall into a deficit. There would be not enough money for any urgent repairs and maintenance. The scheme is unable to pay its day-to-day expenses or comply with a fair trading notice or undertaking or order. So primarily as a scheme, you've got those considerations to really look at, but in addition, our strata managers will be able to enhance and give you that advice. So we're sort of going into that provision of looking at forecasting as well when you're considering a payment plan. Commonly in this area, what we see is anyone that falls into levies and arrears usually falls into arrears 30 days after its due date, and then 10% simple interest is applied. These forms will also provide a provision that an owner can make a request to the committee for the waiver of interest. That is to the committee's consideration, and I've heard multiple views on that today, but I would always share is that a scheme should not be treated to held to account as a financial institution, but should consider its priorities and consider the applicant and the position that they're experiencing. In terms of one scenario of the questions of can we ask for evidence in terms of financial hardship, yes, you can. You are able to make such requests to the extent of maybe a reason would be simple. This information obviously is confidential and is contained on the strata schemes records. However, it is prudent to note on the last occasion when committees are dealing to actual handling of financial hardship or payment plans, they are to remain in the forum of the committee. I've got a couple of questions here, and I might come to them at the end of this slide, just so we capture all this information there. If an owner believes their request has unfairly been refused, they are able to apply for mediation with New South Wales Fair Trading, and if that does not resolve the matter, they may take it to the New South Wales Civil Administrative Tribunal. If the tribunal finds refusal was unreasonable, the scheme must approve the payment plan, and repayments are really important to acknowledge. When we have levies and arrears, they must be added in order of the levy due first, then the interest, and then any arrears charges. Costs, you cannot commence any debt collection just on the basis of costs now. It must be on levies. And it's really important to recognise that part of that is allocating the levy payments for any arrears from a payment plan or any outstanding levies have to be applied to the levy first. While the payment plan is in place and being followed properly, no recovery action can be taken. So once you have an approved payment plan, you cannot commence debt collection. And if you are to then redact the approval of the payment plan because of the circumstance in your scheme or the financial position, please do it in consultation with your strata manager and communicating that with the applicant of the payment plan, providing those reasonable reasons. If recovery action is planned, the owner must be given at least 30 days notice. So for all our clients, we are really pleased to state that there is nothing less. We enact any recovery action with 31 days notice to ensure that ample notice is provided. So a lot of the models that we undertake here at Jamesons actually fall into these compliant means, and we've done so for over many years. What this means for you is standardised handling of payment plan requests. Owners have clear rights to request and, if necessary, appeal to Fair Trading or NCAT. And for all owners, ensure overdue levies are managed without compromising the financial stability of your scheme. Got a question here in terms of who pays for the free financial counselling. That is predominantly by New South Wales Government. There's no cost to an owners corporation. David, I might come to that as next session at the end, if you don't mind. If I've got a bit of time, I'll hop through and answer that there. Has there been any changes relating to defaulting on a payment plan? Well, it's a very good question you raised. So once you've committed to a payment plan, that payment plan must be committed. Now, if a person does default on the payment plan, then the owners corporation is in its rights in providing what we call a Section 86 notice to commence recovery action. So we still have to provide that notice. So it's a unique way to take this approach in terms of addressing it with Fair Trading's enforcement for repairs and maintenance, talking about financial hardship and payment plans all in one change, commencing in one period. It's a very interesting way, but it's probably one of the biggest pain points that Fair Trading receives in terms of complaints. And therefore, I believe that's how this has been announced and introduced for our schemes. We have building manager duties and obligations. And for those that joined our webinar in February and July, we talked a lot about disclosure obligations for strata managing agents. So if you were a familiar face and rejoined this session, just to rehash and recapture, building managers have been introduced with similar obligations. And today I'm going to cover off for you where you've got a building manager, primarily what their obligations are, what to look for if you are thinking about engaging a building manager, what your strata manager will do for you, and not only the building manager's obligations, but what we have done to assist you to ensure your building managers are compliant. So what's changing? Well, building managers will have clear legal duties under strata law. The legislation has changed, and these are clearly stated as follows. A building manager or a facility manager must act in the best interests of an owners corporation or association unless unlawful, promptly identify and report maintenance, repair and safety issues, propose solutions and act quickly on safety matters. New disclosure requirements also dovetail into the changes here in that a building manager must disclose any financial benefits they receive from a contractor. If they receive any commissions or referral fees, this must be disclosed. And today we're going to show you a little bit of a disclosure report that we will be circulating and sharing. Ongoing In addition, we have the ongoing disclosure of suppliers' connections, financial interests, or ownership of lots in the scheme. That must be disclosed. Now, these obligations also exist not just for ongoing services, but they are applicable when recommending contracts and when they are seeking appointment. So I'm going to show you today a very standardized disclosure form, and our wonderful team that's been able to put that together to assist you if you want to ask the question or if the building manager needs a standardized form. Naturally, these come out with obligations to do so, and we can get tangled in emails. But what we've taken here at Jamesons is the approach to be able to prepare this information to streamline and facilitate these requests. Further, we have a clear definition of what and who are building managers. Building managers are appointed under agreements and have ongoing management or control duties. They manage common property operation, ensuring smooth functioning of shared building areas. The important part here is there is an exclusion note that electricians, plumbers, gardeners, and contractors with limited or specific tasks are not considered building managers. So if you're functioning or you've got somebody functioning for you and you're not sure they've got an agreement, please be ensured to get in touch with your strata manager and look at either one, arranging an agreement to formalise the building manager arrangement, or alternately consider reviewing any of the agreements that you have in place. The building manager's disclosure obligations are very clearly set out when they're suggesting contractors and ongoing relationships. Now, I must reiterate that this obligation is on building managers. So while we're here today talking about this session and making this suggestion about ongoing relationships and disclosures, this is very much upon the actual building manager to produce for you. The information we provide you is there to assist you and support you, and also ensuring that they fulfill the obligations. And if you require any assistance, what you're seeing today is all our strata managers have been trained upon exactly in the same manner. Excuse me. So, disclosure when suggesting contracts. Building managers must disclose any benefits they receive or connection with proposed contractors. So they may be an affiliate, they may be a related entity, etc. They must demonstrate and disclose that information to you. This can occur via the strata managing agent or when quotes are submitted or engagement is to occur. This obligation is not just once off. It is at continual disclosure, which is then detailed for suppliers, connections, owner relationships, and financial interests on each and every occasion they are to engage a service provider. Disclosures for building manager candidates. If you are thinking to undertake a tender, looking at changing services, candidates must disclose any referral fees they expect to receive to ensure transparency. Commission transparency that influences charges must be fully disclosed by candidates to avoid conflicts of interest. And benefit of impact of disclosure. Any benefit affecting fee structures must be declared to maintain ethical management practices. So feel free to ask these questions. They are all there. And it's really, really important. We have a sample of a building manager disclosure form here that's been created. I believe this will be readily available from the 27th of October. And these are standardised forms that can be created either for an ongoing disclosure or a pre-appointment of a candidate disclosure. So you can see that information and it helps you understand who and what is making the declaration, the contact, and if there's any value or calculation method involved in this consideration. When a strata committee member acts, strata member acts like a building manager, do these legislative requirements apply, especially if he's not paid? If he's not paid, no, but you should always consult in terms of performing with your strata manager to understand insurance applications. If he's not representing as a building manager, he or she, then that is fine. However, we are starting to get to the place that if you have external contractors or people representing as a building manager and using those terms, please ensure that you have some sort of agreement in place. If you've got past contracts engaged for building managers, we understand that these can be ongoing. We've seen contracts in excess of 30 to 40 years old. We would suggest with the new requirements, especially when you're looking at disclosure obligations, work health and safety requirements, and the provisions of compliance, that you consider in updating those agreements in consultation with the provider. These are good set reasons to ensure that your scheme is being managed to the best and the most up-to-date current legislation. What actions can be taken if the BM does not disclose and fulfill obligations? I'm going to touch on the point of where we review your contracts and that obligation. If in the event a service provider has not complied with law in any provision, and for any service provider, including building management, schemes do have the right to actually provide a notice of compliance, give them an opportunity to make compliant. I mean, if they fail to comply, usually you would provide within 14 to 28 days, depending on your contract terms, would give you rights to reconsider the contract terms and service provider. Now, building manager disclosure obligations. Now, for the building managers, for all those contacts we have, I am really pleased to say that we have communicated to all your building managers for your schemes that we work with, providing an optional disclosure form for building managers to complete and to supply to committees and the strata manager. We understand that their roles are very busy. We do understand that they are practical people that are on foot every day. So we're hoping by providing this information and accessibility, it makes their life easier to continue to provide the services required. If you as an owner or a committee member have any concerns, quite natural to raise this as an inquiry. Please feel free to reach out to your strata manager or our teams, and we will be able to produce assistance in terms of addressing any non-compliance. David, I do hope so fully in that regard. It should ideally where you engage building managers. I couldn't agree anymore. Now, for committee members and for existing building managers, you are entitled to ask them to fill out any disclosure form or provide written disclosure confirmation, similar nature, that is within your legal right to do so. You've got to keep a record of the building manager disclosure. Now, being a scheme managed by Jamesons, that is what we will do under your reports tab in your actual document management system. And if there's any potential issues that are identified, please do raise it to our attention so we can take some action there for you. What it means for you, for owners, for committee members, this is really about the whole year. This year has been about creating more transparency when contractors or suppliers are recommended. It gives you confidence in your providers, your building managers are working with you and in the owner's corporation and scheme's best interests. Early identification and resolution of maintenance and safety issues, remembering that the application of the new legislation also puts the obligation for building managers to properly report and identify any maintenance issues. There's stronger accountability giving committees a tool to end agreements if duties are not met. Now, talking about that final point, we do go on to the next slide here, which talks about new tribunal powers, ending or changing management agreements. A really important part that you'll see today is when we have concerns of non-compliance, usually contracts have a provision to make good. And if that compliance does not achieve, it does give the tribunal powers when they receive applications to end or change any agreements. So from the 27th of October, schemes will have new legal ground to apply to NCAT to end, change building manager agreements or strata management agency agreements. And for those that were in our webinar earlier this year, if you do recall, a new agency agreement was introduced with the terms, and you'll see that, to ensure a reasonable, stable agency agreement. And this will also be applicable to any building managers as well. There are new grounds where a manager, if they have acted unlawfully in their role, failing to meet new disclosure or duty obligations under these strata laws, that provides grounds for a review and possible termination of an agreement. Why this is important to you is that it provides committees, owners, members with a clear, strong pathway to remove managers who are not acting lawfully. It increases accountability to building managers and strata managers. It protects owners from poor practice or hidden conflicts and builds confidence that your building, your asset, your home is being managed ethically, transparently, and in your best interests. Just checking the question. There is a question coming back to payment plans. Is there any limitations set on terms of a proposed payment plan? For example, is there a maximum debt repayment time that the plan must comply with to be considered? Payment plans cannot exceed 12 months. There is no monetary limitation. It is obviously looking at levies in arrears only, not advance. Payment plans cannot exceed a 12-month provision there. So it's really important that you look at that, and our team will advise any applicant of a payment plan that exceeds 12 months to be considered non-compliant. If you have a strata manager undertaking building manager's duties obligations, well, they've got that same disclosure. I hope the strata manager is disclosing their building manager function or operations, but it's really important that they disclose. For strata managers, if we recall, there are approvals required. That would be in your agency agreement. That would also be at each annual general meeting. You'll see a motion about strata managers report. For building managers, if the building manager and the strata manager is one, they will have to do a double down, and I would suggest that is done at your annual general meeting by resolution for clear transparency there. If you don't know who your delegated building manager is, please reach out to your strata manager. It'd be very important that you actually find out who he is and who the contacts are in there. Definitely would be on our files. Okay, so hop over to any questions, because that pretty much covers today's session. I'm hoping that I covered many live. Can the management fees reports be signed off? Yes, they can. How can a building strata committee be changed? There are definitely resolutions at a general meeting required, or attend your next AGM. I'm just scrolling up here. How do new building duties intersect with obligations established in contracts established with the Owners Corporation, which was entered 23 years ago? So the contract outweighs the current legislation. For such an old agreement, we've seen a lot of changes there, Judy, and I would strongly suggest that that agreement is reviewed and updated. We've got a lot of changes in work health and safety regulation and legislation. We've got great risk managements in place that will be able to assist your scheme and assist with setting some good boundaries. If you've had a building manager for that long service in your scheme, you must be doing a wonderful job. I suggest reach out to the strata manager or myself, and we'll be happy to assist in how we can support them to get an updated agency agreement. It's not there to scare anyone. It's just to bring everyone up to the standards. They can continue giving you the great service, especially if it's been there for 23 years. What media is used for the prompt reporting and who can access this information? I'm not sure on that, but what I might do, Noel, is I might reach out to you separately to get clarification on that. If you're not happy with repairs and maintenance that have been done to the property and you've had concrete cancer that's occurred and you've had any issues that arise, it's a very common aspect where disputes can arise with works that have not been undertaken sufficiently. As an owner, as a consumer, as a committee member, you have rights. There is a dispute resolution and you would always have a contract for those works, and you're entitled to definitely demonstrate and dispute and question those works. Always be prepared to ensure that you have sufficient factual information. It is always of prudence for the person undertaking the work, the contractor, to be given the opportunity to come back and do the work. If they fail to respond or do not fulfill their duties, ensure you have that contract handy. There is always a dispute resolution process that can be undertaken and reviewed through the Building Commission office as well. Is there any statutory interest rate on payment plans? I think I touched on that one, but just reiterating, 10% interest is the standard. It's simple interest over 12 months. I know for larger schemes, there is also an application of possible discounts that are being applied as well for early payment of levies. Now, you'll always get the chance to appeal for any decisions or orders that are made. There is always a right of appeal. We do understand concerns that are arising from this, but you definitely do have those rights in that place there. An owner can review invoices, repair contracts, and pre and post repair inspections. That's definitely something you are definitely able to do. If you don't have access to an online function or portal, or you need specific invoices, please reach out to the strata manager and they'll be definitely able to assist. So I've got a question that's not related, but I might touch on that because we've got a couple of more minutes here. We've seen how committees are handling the need to get 2 quotes for works when you use a preferred trade and you cannot get another quote, as other trades won't be using them. Look, the statutory requirement for 2 quotes or more under the Act is any expenditure exceeding $30,000. I understand schemes do have preferred trades. If you have demonstrated a good effort in trying to obtain a secondary quote and you are unable to do it, Section 102 of the Strata Schemes Management Act requires you to note the reasons at your next AGM. I might touch on that one separately there. If you've got repair lights, getting a street light or common property repaired, look, it's not about taking it to fair trading. It's about having common sense discussions. I don't sort of think that the fair trading's approach is simply just on basic, it's a light bulb matter. These are going to be significant issues that are arising. The statistics are showing people are complaining about water ingress, concrete cancer, fire safety compliance, etc., that are all taking into this whole provision of looking at that now. And imagine they would receive a bundle of inquiries, but I would always suggest to any owner or committee member, now that you're aware of your duties, now you are aware of these greater enforced powers, if you do have a backlog, if you do have some areas of concern, speak with your strata manager, have a meeting with the committee, find a practical solution. we do understand there are contributions, there are processes to be followed. Nobody's going to take action against somebody that has not been acting unreasonably, but I want to make sure that you understand that these obligations can come into place. Are there different arrears recovery options in relation to a special levy? No, they're all treated the exact same. So it's levies in arrears, it is those levies in arrears being an administrative, capital works fund, ordinary levy or special levy are treated by same means. So when you're raising a special levy, you would always want to look at your current arrears balance and see what the impacts may be. It's definitely going to cut out our work for us to give you schemes advice to make sure we can update that and generate any buffer provisions in that regard. The reports will be up to date in your portal. You'll have them updated at the end of each month, and they will be actually available online. We will also be distributing these to our owners directly. Detailed management for fee reports will be made available to access at any time. You should be receiving some interim reports, and if you want further details on that, the detailed management report is live. It's in there, you can generate. The real important part is the delegated reports we will be distributing to owners in that. Can an ex-owner of the strata plan lodge a complaint to fair trading? What we've experienced is anyone can lodge a complaint to fair trading these days. It's how they validate it and how they address it. Time-based charges are all broken down into details. What you saw was the first summary page, and then on the second and third page and details, and you will actually see more and more breakdowns of what they make up. The reports to the actual breakdown for your agreed services, your Schedule Bs, additional services, disbursements will be provided in the interim reports and also in the detailed management report, which will also be broken down. If you have a strata manager that is not performing, you're always entitled to convene a general meeting to look at that, or if it is a provision where it needs to be considered, please reach out to us. We do have very, very stable and competent strata managers, especially with the number of training that we undertake here. I think I've pretty much covered everything. I want to thank everyone for attending. I hope everyone has got a lot out of today's session. If you do have any questions, please do not hesitate to reach out. These slides will be provided straight after this session to everyone that's in attendance, and for anyone that registered that was unable to attend, that would also be made available. I believe the recording will also be made available. In addition, what you'll basically also provide is some of these questions and answers that you've raised today. We will also be sharing that. We've received a large number of questions here in today's session, which is wonderful, and I'm pretty sure that can be shared not only across our teams, but also our owners and committee. So I'd like to thank you all for attending and wishing everyone a wonderful evening. Thank you.